Hey guys, welcome to this video. My name is John Watts. I wanted to go through some of the comments that we have received, and we'll start doing this on a more regular basis. I've got somebody who's going to be helping me kind of basically copy and paste the comments into something like what you're seeing on the screen. So let's go ahead and jump right in. Do you accept out-of-state clients? Well, here's a very good lawyerly answer. It depends. So if you've been sued by a debt collector or an original creditor and you do not live in Alabama or Tennessee, then no, we do not take those cases. Uh, I'm licensed in Alabama. I've got a great lawyer who works with me, Blaine Dixon, who's licensed in Tennessee. So we can definitely help you in Alabama or Tennessee. But if you're in another state, you need a lawyer licensed in that state because you've been sued in that state. Now, if you have a lawsuit to file, then again, it depends. Our first recommendation is always to find a good lawyer in your state who can help you. But sometimes that's just not possible. So there are times where we accept clients. They may be, from Missouri or wherever. And then we file their lawsuit in Alabama. It depends on the company we're suing. Can we have what's called personal jurisdiction, which is power of the court over that company? So if it's a national company, then typically we can do that. If it's a local company, then typically we cannot do that. So it just depends. And it also, frankly, depends on the size of the case. Anytime we file a case from out of state, it could get transferred back to your home state or to another state. And just to be blunt, it has to be a big enough case for us to be willing to take on that time and expense. We may have to get a lawyer in your state to work with us. So in any event, it depends. I always recommend try to find somebody in your state first. If that doesn't work, then reach out to me. First of all, I may know somebody in your state and say, hey, call Susie or call Bob or whoever it may be. Or we may be able to help you by filing that in Alabama or in Tennessee. All right, let's go to the next one here. If you're being sued by a credit card company, are they required to let you know of the court date? So it depends. I'll give you a couple of examples. In Tennessee, they typically do let you know about the hearing date, at least the initial hearing date. Typically, that comes with the lawsuit. And again, it depends. And, full disclosure, I don't practice in Tennessee. Blaine Dixon does, but that's my understanding. In Alabama, for example, no. The court lets you know about the court date. And so the other side does not set that date. They don't have to let you know. Now, there may be some unusual circumstance where the court tells them to let you know, but I mean, maybe I've seen that once in 27 years of practicing law in Alabama. So the normal rule is the court lets you know. So what I would suggest is if you have any question about this, first of all, if you have a lawyer, your lawyer would know. But second of all, if you're doing this on your own and you have a question, either call the court and say, hey, is there a hearing date on this? And or call the collection lawyer. Hey, is there a hearing date? Is there a trial date, a court date? And now, they may or may not tell you. I'm talking about the lawyer. The court should tell you. Now, sometimes with staffing issues and depending is your court pretty advanced technology-wise or kind of behind the times, will they be able to tell you right away? I don't know, but it's worth the try, okay? And worst case scenario, you should be able to go to your courthouse, go into what typically is called the clerk's office, and say, hey, I want to look up my case and see if I have a hearing date. So hopefully that helps. Okay, is it accurate to say that debt collectors cannot credit report or sue on debt past 7 years, even if that debt is repeatedly being sold? So basically it's accurate. Let me explain. 3 time periods to collect. We started talking about this, I don't know, a decade ago, and it's still true. There's a time period to sue. That's a statute of limitation. The time period to credit report, that is typically 7 years from when you first go delinquent and you never recover from that delinquency. And then third is the time period to call you, to write you, to email you, to text you, just to do collection other than suing, other than credit reporting. So can they sue you after 7 years. Well, it depends on the statute of limitation in your state. Okay. And then I think down further, there's a reference to the debt began in California, now I'm in Texas. So typically it's the state that you live in that we look at the law and statute of limitation. It could be the state where the contract was entered into, or it could be the state that the contract itself says this will be governed by the laws of Delaware or Virginia or whoever it may be. So the statute of limitation can get a little bit complicated. You just have to look at that. Can they credit report after 7 years after that date of first delinquency? No. They could sell it 1,000 times, 1,000,000 times. None of that affects the period of time that can be reported, that it can be credit reported. So let me just throw this in. If you make a payment or an agreement to pay, depending on your state law, that may extend or restart the statute of limitation. That should not restart the time period to credit report, okay? Unless you bring it current. But normally when you make a $25 payment to a debt collector, that does not bring the account current, okay? But be very careful about agreeing to pay or making any actual payment to a collector. You just have to understand your rights in your state. Have you restarted the statute of limitation? And does that affect the time period to credit report? Maybe on that first one, okay? Very unlikely on the second one as far as credit reporting, but again, you got to read the agreement and understand what you're doing. All right, the original creditor, I assume, hired a collection law firm. Letters continue from this firm with every new debt buyer. Okay. It's a little bit unusual, but I can see that happening. Strange because this collection law firm states this debt is not assigned or sold to them. Firm has been retained by original creditor to collect the debt. Yeah, so this is a great point. So we have original creditor and we have a debt collector. That original creditor can sell the debt to the collector, and then we would call that collector a debt buyer. Or the original creditor can assign the debt to the debt collector and say, we're only assigning it to you for collection purposes, but we still own it. Okay. So let me give you an example. I get a letter from a collection law firm for my Capital One card. Well, probably that collection law firm has not bought the debt. They're just saying, hey, we've been hired to collect. Could be a collection agency for that Capital One or for my doctor bill or whatever it may be. And they may just say, look, the creditor that owns this is still Dr. Smith or Capital One or Discover Card. We're just collecting for you or for them. Or it could be it's sold from original creditor to portfolio recovery to LVMV funding to Midland funding. And so it can be sold to different places. Well, those debt buyers may also hire a debt collector, but still say that they own it, and they just have a collector out there like Capital Management Services. Could be a collection law firm. So in my state, it might be Zarzar and Schwartz or Nathan and Nathan or Brian Cloud's firm or Raustrom. There's a variety of different firms that it could be. And so you need to know what the company that you're dealing with, what they claim. Now in this, it says that the collection law firm states not been assigned or sold. Actually, let me see if I can get this on. Might make it a little easier to see. Not assigned or sold to them. Yeah, so assuming that's true. Now, if it's not true, then you sue the collection law firm for lying to you. But this collection law firm is just acting as a collection law firm. My credit is currently 777. That's great. After following protocols, that debt's fallen off my report. Whoops. Debt began in California, now in Texas. What's the appropriate way to respond if you receive a letter stating you have 30 days to respond or the debt is considered valid? Should I even respond? If I respond, what question should I ask? So, yeah, it sounds like the debt's off your credit report, so that's fantastic. I don't know what statute of limitations is in California or Texas. I would suspect that it's less than 7 years. In other words, if it's fallen off your credit report because it's too old, it's probably too old for you to be sued on. But that would be a fantastic question to ask the collection law firm. So obviously you have to make your own decision. You may want to get with a lawyer in Texas. There's a James Foley in Fort Worth, Bill Clinton in San Antonio. And, you may want to get with the lawyer about that. But look, if this was in Alabama and it was me, I would write a letter to the law firm and say, look, I dispute this debt. It seems to me this debt is too old. Do you say it's within the statute of limitation? Are you saying that you can sue me for this debt? And if it's outside the statute of limitation, what are you going to do? And now another approach would be either following that when they confirm, yes, this is too old to sue, then you may want to send just a pure refuse to pay letter. And that stops the communication. Now, if they sell it to another firm, then you may have to resend that letter, okay, if it's sold to another debt buyer. But if it stays with the same law firm, then they probably have to honor that by not bothering you anymore, okay? So you could send a letter that basically asks questions. I call that a request for information dispute letter. It's kind of modeled off what we do in RESPA with mortgage companies, what's called a request for information. Just ask them questions. Look, I dispute owing this. Do you guys own it? If you don't own it, who owns it? And are you threatening to sue me in any way? Or do you admit that this is beyond the time period to sue me? And then I look forward to hearing from you and see what they say. And if they agree it's too late, then you maybe send a refuse to pay so you don't have to deal with them anymore. So hopefully that helps. All right, if you send a dispute letter and the debt collector, debt buyer does not update your credit report that the account is in dispute in 30 to 45 days. So let me just stop right there. So we send a letter that says in some form or fashion, I dispute this debt, or like the way I like to say it, I dispute any debt that you claim to have on me. That way I don't have to worry about the account numbers or, what if they have two debts and I only know about one? I'm disputing all of them. So the question is, what does that debt collector have to do? Even though I don't agree with this, most of the courts say they have no obligation to update your credit report. But if they do update your credit report, they have to mark it as disputed. So think kind of timeline. You send the letter, they receive it, and then they update your credit report and they do not mark it as disputed, then I would look at suing them for that. Now, months down the road, they may mark it as disputed, but the question is, when they got your letter and they knew you disputed it, and then they updated without marking it as disputed, that should violate Section 1692E8 of the Fair Debt Collection Practices Act. Obviously, you have to look into the details. Does the FDCPA apply? Is this really a debt collector? All that sort of stuff. Okay, but if they don't update, they just sort of freeze the reporting, well, then I would dispute that through the credit bureaus and say, hey, they're not reporting this every month. They're obligated to report this every month, to update it every month. Get rid of this account. And that may trigger them to update, and then we'll see if they mark it as disputed, or it may just get deleted. All right, but going on with the question. So they do not update the credit report that the account's in dispute. And I'm not sure if the person that left this comment is saying they updated it without showing it in dispute, or they just didn't update it. Okay. If they updated without dispute, look at suing them if they just did not update. And then you send them the letter telling them stop communicating. Can they go back and update the account to dispute maybe 60 or 90 days after receiving the last letter from you? Yeah, so the bottom line is whenever they update, whether that's 5 days later or 500 days later, they have to mark it as disputed, or they violate Section 1692E8. Now, in terms of if you send them a refuse to pay letter, that does not prevent them from credit reporting, okay? So I would just kind of, whether you write it out on paper, you put on a Word document, a Google document, or physically you have the papers, I would just sort of lay out and create a timeline. Here's when I sent the letter. Here's when they received it. When did they next update? And did that show it as disputed? If yes, then it sounds like they complied with Section 1692E8. If the answer is no, then it sounds like they violated it. And then if you sent a refuse to pay letter, when was that received? And have they communicated with you after that in a way that would violate the refuse to pay? Just so everybody who's listening, refuse to pay is the same as cease communications. So I hope that helps you out. Very good question. Okay, today was one of the most embarrassing moments for me. I was at work when the receptionist transferred a call to me, but before she put the call through, told me this company had called twice for me regarding an unpaid debt for windows installed on my house. Yeah, that would be very upsetting. So let me just stop right there. So my first question would be, is this a debt collector calling you, or is this the window company or the installation company? Because that's going to make a difference on the Fair Debt Collection Practices Act, which is a federal law. Now, your state law may also apply to, well, let me back up. The FDCPA, the federal law, applies in every state, and it only applies to debt collectors. Does not apply to original creditors. So if this is the window manufacturer, the window seller, the window installer, the FDCPA would not apply. You may have a state version of the FDCPA. In Alabama, we do not. In Florida, there's a version of that. In California, there's a version of that. Maybe in Texas. I mean, a lot of states have that. Okay, maybe Maryland. So then you have to see, okay, does my state version, does it only apply to debt collectors or does it apply to creditors? So Florida's applies to original creditors. So, I mean, there are lawyers who sue hospitals who send out, bills saying you owe this money when you really don't. And they sue under their version of the FDCPA, their state version. So that's what I would say, first figure out who's calling you and doing this bad stuff, and are they covered by law, the FDCPA or your state version. Now, most states have something called invasion of privacy, and that can apply. It has to be pretty bad for it to apply, but it may apply here. So I did not accept the call. I guess they called again. She put them through to my voicemail. What are the rules of engagement for debt collection from a company that's never mailed me a single bill due to my dispute relating to the installation of faulty windows? They even showed up at my house, rang my bell. They're calling me a million times a day. Sent emails, never sent us a bill. So yeah, I would go back to what I said. Is this the company that you contracted with, or is this a debt collector? If it's a debt collector, then what you've described would violate, in my view, the FDCPA. Get with the lawyer in your state about that, who sues debt collectors. If it's the original company, then again, I'd still say get with the lawyer in your state, a consumer lawyer. Do you have a state law that would cover original creditors? Somebody like the window manufacturer, the window installer company. Or do you have something that would be typically called an Unfair and Deceptive Practices Act? Sometimes we call these UDAP. Sometimes they're, like Georgia calls it the Fair Business Practices Act. There's different names. There's basically a law that says we're going to regulate deceptive, abusive, unfair practices by companies. Now, some of those are really, really powerful. Some are just like completely gutted and they really don't do much. But I would check that out again with the lawyer in your state. If you're in Alabama or Tennessee, feel free to reach out to me. If this is a debt collector, I certainly can help you. If it's somebody like the original creditor, I would probably get you to a lawyer who deals more with sort of defects and installation and things like that. Okay, so this person's in Florida. I'm a slumlord, a landlord that refuses to fix anything in the unit. Units develop mold due to a leak. Took our furniture, clothing, shoes, just about everything. What can I do? So very sorry that you're dealing with that. That's incredibly frustrating. We're supposed to be able to stay in our house, our apartment, whatever it may be, and be safe. That's supposed to be sort of our refuge, And if the landlord is not taking care of that, I would get with the lawyer who does landlord-tenant law. Give you two possibilities. One is Florida has a very strong legal aid organization. So legal aid is, well, let me sort of finish my thought. I'll give you a little bit more detail on it. So legal aid in general helps people that are, I don't know if it's based on income or I think it is based on income. And it varies by state, may vary by county. And so you can call, they'll see if you qualify, and then basically you get a lawyer for free. Okay. I know, I forget his last name. His first name is Jim in Jacksonville. He runs the Jacksonville Legal Aid. I want to say he told me it's something crazy. Like he's got 50 lawyers there that work with him. So I mean, these can be pretty big organizations, and they may help with all sorts of things. I think though, landlord tenant is a big part of what they do. I might start there if they say they can't help you, maybe you make too much money or whatever it is. I would just say, well, who's a private attorney in my area that would be good at landlord tenant law? And they likely can give you somebody, or they may be required to give you like 3 names, but whatever. Or you can just search in your city, your county, and then start expanding out to see, okay, who's a lawyer, consumer lawyer that helps tenants who are dealing with this type of terrible situation. And Florida typically has pretty strong consumer protection laws, so I would suspect there's a good landlord tenant law that would help you with that. All right, I live in Tennessee. Do you take on out-of-state clients? Yes, in Tennessee we do, because a lawyer who works with me, Blaine Dixon, is licensed in Tennessee, grew up in Tennessee, lives in Tennessee. That's really what he does, is help people in Tennessee. Okay, this next one was based on some videos I've done, just looking at the number of lawsuits, and I need to do that again, so I appreciate you asking a question. Are you searching lawsuits against consumers? And the answer is yes. In Alabama, I can do that. We have what's called a unified online system, so I can search statewide. Most states are not like that, but I can do it in Alabama. And that kind of gives you a sense of, are the numbers going up? Are they coming down? What's going on with the lawsuits? And then the other question is, or are you searching for consumers filing lawsuits against creditors, collection agencies? Actually, we can do both. That's called lex machina, lex machina. I don't know. Depends on how you want to say it. I need to do that again and just sort of look at the trends of, lawsuits against Equifax, Experian, TransUnion, Portfolio Recovery, LVNV, all those types of companies. So I'll do those again and kind of bring us up to current date. Have you filed suits against National Credit Adjusters? I believe I have. If that's a company out of Kansas, then I have, I don't know, a couple times. It's been a little while since I've done that, but if that's the company out of Kansas, that's my memory of where they're located. Let's see. And just so you know, if you're in Tennessee, if you want to just reach out to alabamaconsumer.com, you'll see a contact form, and then we can get you in touch with Blaine. Okay, can you discuss or pontificate? I'm not sure I can pontificate, but if the usurious, so this is interest rate that's illegally high, it's just too high. In a place that's hypothetically anything above 16%, how can credit cards charge 23, 29% interest rate? So let's say in a particular state that the cap on interest rate is 16%. So how can my Discover card, my Capital One, my Synchrony Bank, how can that be 23% or 29%? Well, here's how they get around it. So that is a state law, okay? So whatever state we're imagining has 16%. That's a state law. There's a federal law, the National Banking Act, that says a bank that is, I may not be using the exact terminology, but I think it's where they're chartered, okay? Then they're allowed to use across the nation basically they can go up to the limit of the law of their state. So not shockingly, banks get chartered or headquartered or whatever the fancy terminology is in states that basically don't have a limit, okay? Or it's a very high limit. And then they can sort of export that to the country, okay? So that's how they can get around. And when there's a conflict between a federal law and a state law, unless the federal law says otherwise, when it hits that state law, the state law collapses, or what is called being preempted. Now, some federal laws will say, for example, the Fair Debt Collection Practices Act, will say, look, if the FDCPA and a state law both govern a particular situation, if the state law is less restrictive on debt collectors or offers less protection for consumers, the federal law wins. If it offers more, then you can use that state law to get more protection. But the National Banking Act says, no, we're not doing that. So there's a lot of controversy. We have these national banks that basically rent their name to these fintech companies. And then the fintech companies go out and make these astronomically high loans, and they go, hey, we're protected because we didn't make the loan. It was this national bank that we just like rented their name. The CFPB is looking at that, Consumer Financial Protection Bureau. Some attorney generals are looking at that. There's lawsuit, private litigation over that. So it's kind of a dirty practice in my view. And I think that will start to be reduced. But to go back to your question, that's how the banks get around it. Is this an illegal contract, unenforceable? No, as long as the bank actually made the loan, followed all the laws of their state. What sort of shenanigans go on to allow this sort of credit? It's that National Banking Act. So, the theory is why this is good for consumers is you allow a big bank to sort of make loans or credit cards all over the nation instead of being forced to only deal with your local bank. The downside is, you do have some of these places that really take advantage of consumers. All right, so I got a letter from LVNV and Resurgent, and just so everybody knows, LVNV is the company that claims to own the debt. They don't really have any employees, so they usually sort of operate through a company called Resurgent Capital, I think is their name. Actually, no, I just sued both of them recently. Let's see, I haven't been sued yet, but I want to get prepared in case they do. I have no income and am disabled, but do have a savings account. When and how do I file my $10,000 wildcard exemption when the time comes, which will cover everything I own? So I guess I would stop there and say, is your savings account, along with all your assets, worth less than $10,000? Normally, when we do an exemption is after there's a judgment against us, which comes after we get sued and we lose the case. So in a timeline, they sue us, they serve us, we lose the lawsuit, they get a judgment, and then they start garnishing, and then we file an exemption to protect our assets. So this is in Tennessee. So you can get with Blaine Dixon, who works with me. Just reach out through alabamaconsumer.com. We'll get you in touch with Blaine. I don't know how those exemptions work in Tennessee. Is there a way to discourage LVMV and Resurgent from suing since they basically can never get anything from me? Sometimes they will back off, but usually they don't. Since they can't really get anything from me, should I try and fight it anyways? Yeah, these two things kind of go together. So let me explain what I mean. So if you're about to file bankruptcy and you tell a collector, hey, I'm going to file bankruptcy, there's no sense in you coming after me, what will they do? Well, in a perfect world, they'd say, well, we're not going to waste the filing fee to go after you. Okay. But the problem from their standpoint is they might, I'm just making these numbers up, they might hear that 100 times for every 5 people that will actually file. Okay. Let me sort of flip it around. Sometimes we sue smaller collection agencies and they go, oh, we're about to go under. We have no money. We have no insurance. Well, then I have to decide, well, do I trust them on that? I just take a little bit of money, or I drop the lawsuit? Or do I say, no, I'm going to call your bluff? I've had it work both ways. I've called their bluff and they did go under. Okay. I've called their bluff and it turns out they have a $5 million insurance policy and the lawyers were lying to me. Now they said, oh, we just got confused. We just were inartful in how we said this company has no insurance and is about to go under when really they had a $5 million policy. I'm not sure how that's inartful. I think that's a lie. But anyway. So we have to decide when we sue the bad guys and they start whining about they don't have any money and, they've got too many lawsuits against them. Do we accept that or do we reject it? Well, from the standpoint of LVNV, if you say, I don't have any money and I'm on disability, they have to decide, do they accept that? Now, sometimes what we do when companies say this to us is we say, well, prove it. Send us your financials. Send us your tax returns. And when they go, no, that's private, we go, well, then we're going to ignore you. LVMV might do the same thing. They may say, well, send us your bank statement, send us your Social Security, award letter, or I'm not sure if you're on, sounds like you're on disability. So you'd have an award letter. Here's your yearly statement that tells about your Social Security. They may do a property search, or they may just say, you know what, that's too much trouble. We're filing 1,000 lawsuits this month in Tennessee. We'll just file and because you might inherit something, right? We might sue you, get a judgment, and then your long lost uncle dies and leaves you, $500,000. Well, then they get their judgment. All right. So the other side of this is, should you try and fight it anyways? I would. You have nothing to lose, right? I mean, if you're truly judgment proof, they can't touch you, they can't get anything, well, then there's no risk to you. Go fight it. If you win, you may be able to sue them. You may be able to get money damages from them. I would definitely talk with Blaine Dixon about this. And again, just reach out through alabamaconsumer.com and we'll get your message over to Blaine and he can help you. Let's see. Oh, and this just goes along with it, just to see if I can get them not be able to prove ownership, etc. Yeah, that's what I would do. Whether you do it on your own or whether you get with Blaine and hire Blaine, I think there's some good law in Tennessee about proof of this type of stuff. Blaine knows a lot about that, and I would definitely get with him. So hopefully that is helpful to you. And I believe that's the last comment that I have at least loaded into this little presentation. So we'll start doing more of these. If you like these, let me know, and I will talk to you guys later. Okay, have a good one. Bye-bye.